As a Canadian, the introduction of H.R. 5518, the Integrated Cross-Border Law Enforcement Operations Expansion Act, has sent a chill down my spine. This bill, if passed, would allow U.S. law enforcement to operate with enhanced powers on Canadian soil, sparking intense debate and scrutiny. As a nation, we must critically assess the implications of this legislation and consider our next steps. H.R. 5518's key provisions, such as the creation of an enhanced cooperation framework and the expansion of officer privileges, seem designed to bolster security along the US-Canada border. However, the granting of legal immunities to foreign officers within our territory raises concerns about potential violations of Canadian sovereignty. The application of US law within our borders also poses significant questions regarding jurisdiction and due process. Proponents of the bill argue that enhanced cross-border cooperation is necessary to combat alleged threats, such as the influx of dangerous individuals entering the US through the northern border. While I acknowledge the importance of maintaining strong security relationships with our allies, I cannot help but wonder if this bill is merely a veiled attempt at exerting US influence over Canadian affairs under the guise of cooperation. The fact that conservative US representatives have largely backed the bill, while Canadian officials have remained cautious, is telling. Their hesitance is understandable, as it reflects a deep-seated worry about sacrificing national autonomy for the sake of stronger security ties. As Canadians, we must be vigilant in defending our sovereignty and ensuring that any cooperation with our neighbors does not come at the expense of our hard-won independence. So, what can we do as Canadians in the face of this bill? First and foremost, we must engage in an open and informed discussion about the implications of H.R. 5518. We must educate ourselves on the details of the legislation and consider the potential consequences for our nation's security, autonomy, and relationships with the United States. Secondly, we should demand that our government, at both the federal and provincial levels, takes a firm stance on this issue. Our leaders must prioritize Canadian interests and make it clear that any cooperation with the US will be done on our terms, respecting our sovereignty and fundamental rights. Lastly, we must be prepared to take action if necessary. As a nation, we have a long history of standing up for our values and protecting our way of life. If H.R. 5518 were to be passed without sufficient safeguards for Canadian interests, we may need to consider diplomatic measures, such as engaging in direct discussions with US officials to express our concerns, or even taking legal action to challenge the legitimacy of the bill. Make no mistake, this is not an invasion of the US by us. Rather, it is a clarion call for Canada to assert its position as an independent nation, capable of making its own decisions about its security and sovereignty. As Canadians, we must stand united in defending our values and our country, even in the face of pressure from our largest trading partner and neighbor. H.R. 5518 is a complex and contentious issue that requires careful consideration from all sides. As Canadians, it is our duty to remain vigilant, engage in open dialogue, and advocate for our nation's interests. By doing so, we can ensure that any cooperation with the US serves to strengthen our own security and prosperity, rather than eroding our hard-won sovereignty. The future of our nation depends on it.